Hi folks, welcome back to SQE1 window, and here we start chapter 4 in our criminal law, participation in crime and secondary liability. So why this matters? The key thing is to understand criminal liability is not just for the person who actually commits the crime. So think of it like most serious crimes involve teams. You have got planners, lookouts, gateway drivers, weapon suppliers. Should they escape liability just because they did not pull the trigger or throw the punch? The law says no. Secondary liability treats aiders and encouragers as responsible when certain conditions are met, often with the same maximum penalty and as the principal offender gets. So in SQE exam, watch these exam triggers: the gateway driver scenario, the weapon supplier question, or someone saying, I only watched. These are classic secondary liability situations that you need to recognize for your exam. So principal versus secondary parties. Let's discuss the basic map clear. A principal offender is the person who actually commits the actus reus with the required mens rea. So they are the one doing the physical act of crime. A secondary party aids, abets, counsels, or procures the offense at that point. So they are helping or encouraging, not directly committing it. So now here is something crucial. You can have more than one principal. If two people both stab a victim, they are joint principals, not one principal and one secondary party. Both are committing the actus reus directly. And here is the really important bit. Secondary parties can be convicted of the principal offense itself. The gateway driver can be convicted of robbery even though they never entered the bank. They are tried and punished as they were principals. So watch for exam trigger like group assaults or scenarios where two people both strike the victim. All of it comes under this session. So the next thing is joint principals and innocent agents. So joint principals liability is where multiple parties each commit the actus reus with the required mens rea. Think of a gang beating. If everyone is punching and kicking, they are all the joint principals in the assault. Innocent agent cases are fascinating. This is where person A uses person B as a tool to commit a crime. But B lacks mens rea or capacity. For example, if you trick a courier into delivering drugs by telling them it's just document, they are liable as at that point you are liable as a principal even though the courier did the physical act. Or using a child to deliver a package, the child might lack criminal capacity, but you are the principal because you are using them as an innocent agent. The key exam trigger: look for someone being used or tricked into doing something. So what are the statutory foundations? So the legal gateway for all of this is Section 8 of Accessories and Abettors Act 1861. Yes, more Victorian legislation still in force. Section 8 covers aiding, abetting, counselling or procuring any indictable offence. So here is the important bit. There is a statutory fiction. The accessory is tried and punished as a principal. But liability still depends on proving distinct actus reus and mens rea for complicity. It's not automatic just because the principal is guilty. Exam trigger here is question that says someone is charged with the same offense as the principal. That's statutory fiction in action. So the next thing is for routes to liability. The first is aiding is giving practical assistance. Even before or during the offense, think providing tools, weapons, transport, all of it. Abetting is encouragement or instigation, often happening at the same time as the offense. Go on, do it, hit him. That's abetting. Counseling is advice or encouragement given beforehand, planning meetings, giving instructions before the crime and all of it. So procuring is the strongest. It means causing the offense to happen. This one actually requires causation. So what for these exam triggers? Look at scenarios for aiding someone, shouting, encouraging, for abetting, planning messages for counseling, and spiked drink driving for case of procuring and all of it. So next is aiding assistance, can be minor, but still that counts. So let's try to understand that how aiding works. The help does not have to be essential or substantial, but it must actually be given. Just offering help that's not taken up does not count as aiding. The famous case of AGs, like reference number 1 of 1975 with the oxygen cylinder examples, even the help was not essential. Like the principal could have gotten the tools elsewhere, it can still be aiding if it was actually provided and used at that point. So they can't say that they would have taken it from somewhere else as well, So exam trigger, don't fall for the argument they could have gotten it elsewhere. That's not a defense. If you provided assistance and it was used, that's aiding, that's enough. So the next thing is aiding, encouragement, and mere presence trap. Abetting is encouragement. And this can include presence that emboldens the principal, But here is the trap. Mere presence alone is not enough without encouragement or assistance. The case is Clarkson. Just being there as a passive observer does not automatically make someone guilty. There is an important exception, though. If you have a duty to intervene or control the situation and you fail to do so, your presence might count as encouragement. Think about parent present during child abuse who does nothing, or a police officer watching a crime without intervening. That duty to act make their passive presence potentially criminal. So exam trigger, spectator at a fight, that's testing mere presence. Ask yourself, did they encourage or just watch it? That's it. So the next thing is counseling, and that is counseling and advising, soliciting or encouraging before the offense happens. The key is timing. It's beforehand, not during. That's what you need to understand it. The advice must play some part in the commission of the offense. Interestingly, even if you are just reinforcing an intention the principal already had, that can still count as counseling if it strengthens their resolve to commit the crime. Make sure you distinguish timing. Counseling is before, abetting is during. So exam trigger, text messages, planning a crime, someone saying you should do it tonight. That's counseling, not abetting, because it's beforehand. Next thing is procuring, and that's tested. Procuring means producing by endeavor. You're causing the principal offense to occur through your action. The classic case of AG, reference number 1 of 1975 again. But the drink spiking example, someone spikes another person's drink. That person then drives drunk. The spiker procured the drink driving offense. What's fascinating is that procuring can work even where the principal does not know what's happening. And even in strict liability offenses, the principal in the drink driving case did not know they were over the limit, but the procurer is still liable at that point. So exam trigger scenarios where someone sets up circumstances so an offense happens, especially where principal did not know all of it. So here is your exam method of checking actus reus for secondary liability. The prosecution must prove 3 things. 1, a principal offense was actually committed. If it was not, forget secondary liability. Look to inchoate offenses. Instead, under the Serious Crime Act 2007-2, the defendant did an act of aiding, abetting, counseling, or procuring. 3. There is a sufficient link to the offense. Like for procuring, that means causation. For the other, contribution or facilitation is enough. Important exception: the intended victim of an offense cannot be an accessory to the offense. A child cannot be an accessory to their own sexual abuse at that point. So in exam scenarios where a principal backs out or a child consent to something, you need to be careful on those language used in exam questions. So links and causation, this is really important for aiding, abetting, and counseling. You don't need but for causation. Contribution or facilitation is sufficient. The cases of Bryce, like we got, and they confirmed this principle. So even if the offense would probably have happened anyway, if you contributed or facilitated, that's enough. But procuring is different. Procuring does require causation. You must have actually caused the offense to occur. So exam trigger, don't be fooled by arguments like the help was small or it would have happened anyway. That's not a defense for aiding, abetting, or counseling. So mens rea structure, we got two-part test here. The mens rea for secondary liability has two parts and you need both. Part 1, intention to assist, encourage, or procure. This is intention as to your own sportive conduct. Did you intend to help or encourage? Part 2, knowledge or awareness of the essential matter that makes the principal offense criminal. You need to know the type of offense, but not very detail of it. Two crucial cases, NCB versus Gamble says you don't need to desire the outcome or have a criminal motive. Just doing business or making profit does not protect you. So and Brainbridge says not knowing the exact target or exact time can still satisfy mens rea, that you don't know what's going on but you know that a crime will happen. In exam trigger, a seller saying I was just doing business, or supplier saying I didn't know which house they will rob, I didn't know the specific house number. Neither excuse work if they had the required knowledge and intent that what I am giving them will be used in crime. So Jogi revolution, the 2016 Supreme Court case, Jogi fundamentally changed secondary liability law, especially for joint enterprise murder. Here is the core correction: for sight of a possible offense is not the legal test by itself. The old law said if you foresaw your mate might stab someone, that foresight alone could make you guilty of murder. Jogi said that's wrong. The prosecution must prove you intended to assist or encourage the offense. Foresight is just evidence from which intent can be inferred. It's not enough on its own. So this has had massive impact on murder cases involving joint enterprise. Just knowing your friend might do something is not enough anymore. The prosecution must prove you intended to assist or encourage. So exam trigger, I knew he might stab someone, but I hoped he would not. Post Jogi, that's not automatically secondary liability. That's what you need to keep in mind once you go to your SQE. Withdrawal, pulling out. Can you get out of secondary liability by withdrawing? Yes, but withdrawal must be effective, and what counts as effective depends on what you did. You must communicate your withdrawal, and if you provided practical assistance like weapon or tool, you need to take reasonable steps to neutralize that assistance. If you just gave encouragement, leaving the scene plus clear communication must be enough. But if you provided a weapon, you need to do more. Maybe retrieve the weapon or inform police. So at that point, you cannot hand someone a knife, then say, I'm out 5 minutes before they use it and expect that to work. Exam trigger, someone who leaves the scene, someone who previously gave a knife, someone who stops showing up on the planned day. All of it you need to keep in mind once you decide on withdrawal. So let's discuss our favorite slide. First, don't confuse joint principal with secondary parties. If both people commit the actus reus directly, they are joint principals, not principal and accessory. Second, don't treat mere presence as abetting without evidence of actual encouragement or a duty to act. This is one of the most common mistakes. Third, always separate actus reus from mens rea in your analysis. Ask, what did the defendant do? Then ask, did they intend to assist and did they know the essential facts? Fourth, for procuring specifically, always ask, did defendant actually cause the offense? Fifth, post jogi, remember that foresight is only evidence, not the mens rea test itself. You must prove intention to assist or encourage. Sixth, withdrawal, very important, requires more than just changing your mind. The more assistance you gave, the more you need to do to withdraw effectively. If you gave weapons, mental withdrawal is not enough. I changed my mind. Finally, if the principal offense is never committed, pivot to inchoate offenses under the Serious Crime Act 2007. No principal offense means no secondary liability, but there might be a liability for encouraging or assistance. So I wish you all the best. I hope this makes sense. If you like this session, press the subscribe button and share it with your friends. I wish you all the best with your exam. Ta-da.